When we, as a group, not only this subcommittee in mental behavior, but as the whole CAT Development Ministers Group read this, we all interpreted the A as a article. An article. There's another way to read this simple letter A. What's another definition for A? One. So if you read it as an article, this would suggest class 4 or class 5 impairment across all of chapter 14. If you read this as a number, it would suggest that all you need is 1, which could mean any one of the 4 subcategories. So we had, in total, probably the number of people around this table right now, and not one of us ever thought to read that as the number. We all read it as an article, and as such, we used the interpretive method that I just talked about, where you need to have at least 2 marked. When the arbitrator from McMichael read this, however, and when Justice Spiegel in the Debian decision read that, however, in both those cases, the orbiters, again, the sidebar comments, were that their interpretation was A as a number. So that then led to an evolution, in a sense, of case law going up the ranks all the way to the Ontario Court of Appeal. And again, Justice Spiegel had spoken of the single domain, but didn't rule on the single domain. You might have heard, has anyone heard of the Pastore decision? Yep. Yes? Okay. So it's the most recent CAT case that's gone to the Ontario Court of Appeal. It was my case, and in this situation, this involved a woman who had chronic pain in isolation with no other significant psychopathology. And what I had become aware of, I became aware of the Michael decision and the sidebar around maybe all you need is 1 class 4 marked. But I also, by that point in time, was acutely aware of the Debian decision. Folks are familiar with the Debian decision, which allows the integration or the combination of the physical and the psychological. And in that case, again, I'm going to kind of abbreviate things in the interest of time. We had an individual who had been paraplegic premorbidly, who was involved in an accident. Because he was a para premorbidly, that part of the AMA Guide's rating could not be applied. Basically, you couldn't use that towards the 55%. He would have been 55% already as a para. So what was invoked? He had some injuries. He had some MSK injuries, and he had some psychological impairments, meaning like a depressive disorder, what we consider about a moderate level. And his impairment rating physically, and I don't remember the exact number offhand, but it was somewhere in the neighborhood of, I think, 35%, exclusive of his paraplegia. And the argument was made that you could take somebody who technically had a 55 or 60% based on their psychological impairment alone. That would meet. You could take somebody whose physical impairments alone met 55% or more. But when it came to somebody whose physical and psychological impairments were basically equivalent functionally, the argument was made that in the AMA guides, there was no way to combine those, in part because in Chapter 14, they talk about moving away from percentage ratings since the second edition and no longer allowing these combinations of physical and psychological. So Justice Spiegel basically referenced the Canadian Charter of Rights and Freedoms. It's really the only time that for CAT purposes it's being invoked. and recognized that this represented a discrimination on the basis of disability. That if you can't, according to the Charter of Rights, have two equally or three equally disabled individuals, where two of those individuals would have access to catastrophic impairment status, and the third, because his or her functional limitations were derived from a combination of physical and psychological, and have that person not have access to catastrophic entitlement. So that is how basically the combination of physical and psychological came about. Having read that judgment, the appeal to the Charter, as well as having recognized that now two justices have, or a justice and an arbitrator have recognized that one marked impairment was sufficient, I now felt that the case law had told us what the proper way of dealing with these cases was. Before that, chronic pain wasn't considered to be an area that you could rate on in and of itself. I'll discuss a little bit more about that shortly. So what I put forward was the first case whereby an individual with chronic pain alone, without any psychological, and who only had one marked impairment, met CAT status. And so it ended up going all the way to OCA, Ontario Court of Appeal, and was supported on that basis as of late 2012. So what was unique about Pastore, again, was after it became clear, after the directive was there in terms of the Charter of Rights being invoked in case law pertaining to the MVAs, it became, I felt, appropriate to invoke it in this kind of situation as well. So that's why ultimately we now have Pastore reflecting and giving us the ability to rate strictly on a pain disorder, even when there are no other psychological full-blown diagnoses being considered. If IE companies are telling you, for example, that chronic pain in and of itself is not rateable, if an IE company is telling you that you have to have a marked overall or at least two marked, these opinions that were put forth very heavily by insurers, fought very heavily by insurers, have now been lost at the highest level of Ontario Court. They haven't been appealed to the Supreme Court of Canada. It's not anticipated that they will be, but that would be the next step if they were to be. So that is the law of the land currently.